Hey, everybody. This is Kathy. Welcome to this very unprepared live that I decided to do very impromptu, as we do around here, because I looked at some of the content that we've put out over the past several days, indeed, over the past years since I started my podcast on it's on Spotify, but it populates onto a number of different platforms, including here on YouTube. And we've had this YouTube channel for maybe, I think it's about 14 months right now. Podcast is a lot longer in tenure. And I looked at everything that we've been doing and what's been going on this past week, really yesterday, and what's coming up on Tuesday. And it dawned on me, hey, William, glad that you're here. Thank you. Thank you for being here for our impromptu live. There's really, in a period of about 4 days, three cases in the federal, not state, but federal court system, two of which directly relate to State of Idaho versus Bryan C. Kohberger, which I know that many of you have been following as good citizens for a very long time, perhaps even since the case started as it did back on December 29th, 2022, with the filing of the warrant affidavit, aka the affidavit of probable cause, for the more than 2.5 years that it was active, highly sealed case, through the time of Mr. Cobberger's sentencing about 8 months ago. And you've been following the case. I like our channel, both here on YouTube and Spotify, because people are from all aisles. Some people feel that Mr. Kohberger was the sole and correct perpetrator. Others feel that he was not the sole, but he had involvement. And still others feel that he's a scapegoat. He had zero involvement. And we've had a lot of respectful conversations, as we do under the First Amendment to the United States Constitution. And as I was looking at our content today, I realized that perhaps no other time since I got involved in this true crime, I guess for want of a better term, genre, with the publication of the Idaho versus Cobberger podcast on Spotify, that there's no other period of time that's as important as this in terms of Mr. Cobberger. And I want to just, before I get into explaining why with relation to three federal court actions, I want to say first, thank you for everyone being here live. I appreciate it. If you could hit the like button, I'd really appreciate it. For those of you that join us sometime later, if you could do the same, I would appreciate it. And if you're listening on repeat, the same. Okay. I really greatly appreciate the likes. It helps our channel grow. And I want to welcome again, William. Thank you for being the first in the door. I appreciate it. Mamo's Thinking, great supporter. Blueberry, wonderful supporter of my channel and me for a very long time. And then we have, hi, that on point Rican. Thank you for being here. Thank you all for being here. I got involved with the Cobberger case when I was looking to change my podcast. I had a podcast for a number of years, and it was on everything independent speech, independent people, independent businesses, independent broadcasters, independent music. If it's independent, not corporate owned, I'm all about it. If I'm ever walking down a street and I want a cup of coffee and there's a chain on one corner and a mom and pop, the few that are left, on another, I'm going to pick that mom and pop every day of the week and twice on Sunday, to quote, in a way, Judge Stephen J. Hippler, but that's just me. And I started to report on the Cobberger case. And what we did, I think, is rather unique, is that we started with the affidavit of probable cause. and in 5-minute bites went over every single item that is on that court docket. And we've been doing that. I thought my days were coming to an end with the Kohberger case, going to jury trial in August, and then we all got the stunning news, myself included. I was quite stunned about the change of plea that happened. I didn't see that coming. But then again, it's a product, I believe, because of the highly sealed, very unusual nature of this case to be sealed like this on top of a gag order that was in effect day 4 of the case, which meant we never got to see the types of things you'd see in other cases. You'd see law enforcement come out once in a while and give an interview, or the prosecution or the defense do a press release once in a while, or even do a press conference. We saw none of that in the Cobberger case ever, from soup to nuts. It wasn't until the gag order was finally lifted in July of 2025 at the request of the Media Coalition that you started to see, at least on the state side, some press. You saw a press conference right from the Ada County Courthouse, July 23rd, 2025. We saw the chief of police give interviews. We saw various detectives involved in the case give interviews. We saw experts give interviews, appear at CrimeCon. And we saw some of the family members and the people that were involved also appear in documentaries or come out and speak. The only side that we haven't really heard from is Mr. Kohberger himself and his defense team. We haven't heard, and I'm wondering why things are so quiet on that realm. And it may be because of one of the cases I'm going to talk to you about here in just a minute. But to welcome some more people, thank you, Mama. Reigning Rebecca, oh my goodness, thank you for being here today. Thank you. All right, guys, and I'm speaking the way that I do because I'm so familiar with that docket. I mean, literally with my podcast, the Idaho versus Cobberger podcast, which is the first I have done. We went through from the very first filing, affidavit of probable cause, criminal complaint, the order finding probable cause, and then the arrest warrant. Those were the 4 things that were issued day 1 of the case, December 29th, 2022, all the way through 2023, 2024, 2025, and now into 2026. I look at every single item on that court docket and some things just from the case summary page that are under seal. So I'm familiar with it. Our podcast is available on repeat here on the YouTube channel, although it populates out onto Amazon and iHeart, and I don't even know where it goes, which is fine with me. The more it goes, the better. I'm happy. I'm happy about that because I feel that it's almost like an audio book of the case that will be there for perpetuity. And I've been asked if I would be interested in selling it, and that came with a big fat no. No way. That was a something that I did from the heart, and I wanted to do. And I was very disappointed that it didn't go to trial, and I'm still disappointed that much of the case is under seal, because I think that the First Amendment required this case not to be under seal. And I think that the public and everyone here that follows this channel is intelligent enough to read the documents. I can maybe give a little bit of help by saying, what are the pleadings, and what is oral argument, and what's this motion to strike, WSU's answer. I can give you a few things, but my followers, the people who support my channel, the members, are extraordinarily intelligent. And they are capable enough to read the documents for themselves, but they can't, because about 95% of that case is still under seal. The only thing that's been unsealed now, and it's perplexing to me, because if he's the only person who had any involvement at all in the case, and there's no one else, no accessory before the fact, after the fact, no alternative perpetrators, and no co-conspirators, why is this case still under seal 8 months after the man pled guilty? That just doesn't sit well with the ulcer in my stomach. It's why hasn't the case been unsealed? That's a question I can't answer. I've asked myself that many times. I've discussed it with other people, but I do know that about 95% of this case is still under seal. The only things that have ever been unsealed, few documents from March, April, May, and June, that came from the first and the second court order that Judge Hippler rendered to the parties regarding unsealing of documents. Not everything, but a few things. And then when we started to get into the meat and potatoes, to quote harsh reality a little bit, which was January, February, and March, the time of the in limine filings. And I speak specifically about February and March. All of a sudden, things came to a halt. This third order regarding unsealing January, February, and March was issued October 16th. That's almost going on a half year ago almost. And Judge Hippler on December 18th, he ordered the unsealing of dozens upon dozens of those documents. And a lot of those documents under seal have to do with evidence. And so far, only one has been unsealed. And you saw it the other day. It was about in limine regarding text messages. Now, what's motion in limine? Motion in limine, a motion, as you guys know, it's an application or request for a court order. In limine means pre-trial. Back in February and March of 2025, there was still a trial that was in the future. So what the parties were doing is each side was filing a motion in limine, asking Judge Hippler for a court order, in limine meaning pre-trial, regarding evidence. Should this evidence come into the trial judge and be exposed to the jury or judge? Is it too prejudicial? Is it irrelevant? Is it untrustworthy? Other reasons why it shouldn't come into the case. That's all the motions in limine are about, okay? So what were the in limine filings? And remember, when you get briefings, motion, response, reply. The motion is the moving party. The documents you saw the other day unsealed, that was a state motion in limine regarding text messages. They wanted text messages to come in and be put before the jury. The defense came back and filed a response in opposition. And what they filed in opposition, they filed the text messages themselves. That's what got unsealed the other day. Redacted, but that's what got unsealed. So it goes motion, response, and then reply. The originating party gets to reply to the response. So when you see something like what got unsealed the other day, recognize it's not standing alone. It's replying to something else that had stuff that was filed under seal. So I don't know why here we are, 8 months later, and this case is still 95% under seal. He hasn't even gotten into entering an order for 2024. And that's when things really get interesting, ladies and gentlemen, because that's all the motions to suppress, and that's the motion for the Franks hearing. And there's a ton of stuff under seal that were filed with the motions to suppress, the responses there too, and the replies there too. And oh, by the way, the Franks hearing as well, everything denied, everything, every single one of those motions were denied. The end of November and December of 2024 was when all of that action was happening. Judge Hippler hasn't even entered an order for 2024 at all. So is it going to take 5 years to unseal this case? And then what he's doing is there's more things that are being sealed to the public even after the closure of the case. In September, there were things that were filed under seal. October, November, December, January, this month, the last two things that were filed under seal. When's he going to circle back and then deal with however many years of additional filings are under seal? I mean, this case is just... It's baffling me, the secrecy of it. If he's the sole and the correct defendant, unseal the case because there's nobody else to charge, right? If you're not unsealing it, then why? Okay, I'm waiting for the motion in limine. Blueberry is waiting for all of the motions in limine. You and me both, Sarah, you and me both. No good reason for Hippler to keep everything sealed. I think a lot of people can only agree with you, Rebecca, on that point. If they had probable cause to arrest Bryan, then why go through a secret grand jury indictment? Oh, let's not. Hi, Al. Good to see you. Thank you. What Blueberry is, another very, very perplexing aspect of the case. For those of you that have joined the case maybe later on, it's been a while. When Mr. Kohberger voluntarily returned from Pennsylvania, and I don't understand why that happened. That's another conversation for another day. But when he voluntarily returned from the Commonwealth of Pennsylvania to Idaho, as he did, remember that cross-country trip with that tiny, tiny jet that had to keep stopping every 20 minutes to refuel because it didn't have a full tank, to be able to make it across the country. That was the Commonwealth of Pennsylvania State Police plane. He came back. First day in court, he had made his first appearance. And the second court date, they talked about, okay, when are we going to have this preliminary hearing? Because he was arrested on the strength or weakness of the affidavit of probable cause, aka the warrant affidavit signed by Detective Brett Payne under penalty of perjury, 29th of December, 2022. That directly led to the order of probable cause and the warrant for Mr. Kohberger's arrest. Without that affidavit of probable cause, you probably, and I probably, would have never heard of his name. So they have their appearance in court in January of 2023. And both sides, the defense agrees to waive a speedy preliminary. Almost like what we just saw with the Nick Reiner case. He was arrested. We're covering that case as well. He was arrested in mid-December of 2025. There were a couple of court appearances. The first appearance, his private attorney had just gotten on the case and said, we need to reset. We're going to waive speedy preliminary hearing. And Reiner agreed to it. And then next hearing in January, it was January 7th or whatever it was, then came the news that his private attorney was, had to leave the case. And then, so now he's got the public defender. He only had his preliminary hearing this past week. It was February 23rd, I think it was. So in any event, what Cobberger did is agreed to waive speedy preliminary hearing to see if there was enough evidence to bind him over until trial. And what both parties did, and you can go back, I'm sure it's still online somewhere at the hearing, when it was Judge Megan E. Marshall. She was the first judge on the case. She also is the jurist who signed the warrant affidavit and who signed the warrant for Mr. Kohberger's arrest on the strength of the PCA. They scheduled a preliminary hearing. It was going to be the last week of June of 2023. And this is kind of going back to Blueberry's point here. And then, so both sides, they both committed to it. We're going to have a public hearing. You're going to present your evidence in open court. And then Judge Marshall is going to then determine if there's enough to bind you, Mr. Cobberger, over for trial. So what had happened was at that time, do you guys remember the talk about bringing back BF, one of the roommates, for that preliminary hearing? There's a document that Judge Marshall had signed. They were trying to get her to come back because she was out of state. And then finally, what the defense agreed to do was to go and to speak with her because they felt that she had exculpatory evidence. And then what had happened is, boom, you open up the court docket. I'll never forget it. I'm getting ready to do my my podcast it was May 16th, I think it was. I believe it was May 16th. Indictment returned by the grand jury. So what that did, this is a really old concept. It's ancient. It goes back. We talk about ancient. We go back to the Commonwealth, common law days when we were still part of England and everything else, and even before we were part of England. That a prosecutor can go in secret and convene a grand jury with no one else there but the prosecution. So he's going to direct everything. That's why they say that a prosecutor could indict a ham sandwich. All the witnesses, if you don't come, you're going to be hit with contempt of court. If you do come, you can't have a private attorney being there. So whatever witnesses were at that grand jury, and we don't know because it's secret, they couldn't even bring their private attorneys in with them. And then whatever evidence that was produced, you don't have the defense there. Oh, objection, that's hearsay. Object. Nope, defense isn't there. Defense is not allowed in the room. The indictment came back. Bye-bye preliminary hearing. At that point, things were kicked upstairs, so to speak. And that's when the district court judge, John Judge, took over until what happened. Remember back January 30th of 2024. Do you all remember? That was a big day in the case. January 30th, 2024. That's the day that Mr. Cobberger filed the motion for change of venue. And they fought over that for a good part of 2024 up until September. Hey, AR, good to see you here. Good to see you. Thank you for being here. So they fought over that for a good 9 months, and there were some fireworks. Mr. Kohberger at one point accused Judge of violating his due process privileges when ex parte there was an order that required, remember I'm trying to think who the professor was that was going out and doing all of the surveys. The defense was doing surveys. They needed competent evidence to show that he would have been prejudiced in Latah County. And so in order to do that, they hired a professor to come out, and he, did his surveys. And well, Judge on the estate's motion stopped that. And that's when Judge was accused of violating Mr. Kohberger's 14th Amendment privileges of due process. And we know how much we love the 14th Amendment. What are the three things? Notice of what the government wants to take away from you: your life, your liberty, your property, opportunity for you to be heard, and the key, the juice that runs our criminal justice system: a fair and impartial judge. And if there's a jury trial, a fair and impartial jury. So anyway, hi, Richard. Good to see you. Good to see you. We've got a lot of people here. Real T, thank you for being here. Guys, if you could hit the like button, it would really help me a lot if you haven't had a chance to do that. So anyway, Mr. Cobberger got his wish when Judge granted that motion for transfer of venue. And then what happened? The Idaho Supreme Court steps in. Idaho Supreme Court decides what county the case is going to be transferred to. It's going from Latah County to where? Ada County. Why? Because the Idaho Supreme Court entered an order saying that. And moreover, the Idaho Supreme Court appointed Judge Stephen J. Hippler. That's how that happened. People wondered, how'd this case wind up in Ada County? Well, it's because of Mr. Kohberger's motion to transfer venue. Sometimes people say, in retrospect, maybe he should have stayed in Latah County, maybe not, maybe it would have still been the same outcome, because hey, guess what? The two judges in Latah County, they also signed every order that was every motion that was put in front of them to seal the case. Every one of them. Nobody ever denied a motion to seal. Hey, Perfectly Broken. Good to see you here. Thank you for being here with us. Thank you. So there we go. We're now, Hippler did 100%, as Mama was saying. So Hippler becomes the judge. It was mid-September of 2024. And he just continued on with the sealing of the case. So here we are 8 months later. Case is still largely 95% under seal. Now, I promised we would speak about 3 federal cases connected to Mr. Kohberger, who's sitting in prison right now, as he has been. Hey, stop the BS. Glad that you're here. Thank you for being here. Mr. Kohberger sitting in a state prison outside of Boise. Why are we talking about federal cases? What? Well, because they are all directly or indirectly associated with Mr. Kohberger. The third case we're going to talk about is probably one of the most important cases to Mr. Kohberger and people like him who have signed away appeal rights. Let's talk about the first case. We have been covering Scofield versus Giard for some time, both on our podcast and here on this YouTube channel. It was the second case I covered because at first the intricacies and the scope of Idaho versus Kohberger made me realize if I'm going to cover Idaho versus Kohberger, it's got to be that case and that case only, or I don't cover Idaho versus, because there was just too much there. Then the second case that we decided to cover was Scofield versus Giard, which was filed in federal court in Idaho by a University of Idaho professor who sued a tarot card reader / content creator over on TikTok for defamation, 2 counts. You know when that complaint was filed? December 21st, 2022. That's how long this case has been proceeding. It is older than the criminal case of Idaho versus Kohberger. Oh, and by the way, the plaintiff's attorney, Professor Scofield's attorney, represented the media coalition in Idaho versus Kohberger several times. She appeared in Latah County back in 2023. She went to the Idaho Supreme Court trying to get that gag order set aside in 2023. She reappeared in the case in Ada County in January of 2025, seeking to have Judge Hippler unseal certain documents associated with the motions to suppress evidence and also the Franks hearing, and to open up a hearing, one of many that had been closed to the public in the case. So she reappeared in January, and then she reappeared in July again, successfully got that gag order finally set aside, but the motion to open the case and unseal the documents, that was denied. That's when Judge Hippler announced this. Every few months at a time, we're going to go and we'll have this process about whether they're going to continue sealing the case to the public or unsealing it. But any event, case of Scofield versus Giard, 2 counts, 2 claims. Did you guys see the verdict form? Did you guys see the verdict form? Elle's predicting, she's always believed this would become a Supreme Court case. Well, one step away, Elle. One step away. Has anyone seen the verdict? I published it on the docket yesterday. We've been following the trial. We said we would do it gavel to gavel. We would do it from the beginning of the case, and we did. We gave you periodic updates. We knew that this was going to be a 4-day jury trial in Boise last summer when the court ordered that it would be in Boise. It was supposed to be in federal court in Moscow, but the federal courthouse in Moscow closed down. So then it was transferred. The trial was going to be in Coeur d'Alene, but then it was decided, let's do it in Boise. So we knew from last summer this was going to be a 4-day jury trial in Boise, Idaho. The defendant, Ms. Giard, represented herself pro se from the beginning of the case. That means she has no attorney. She's going into this monster of a federal lawsuit representing herself up against a great law firm. And but she was really assertive in her case. She filed counterclaims. Unfortunately for her, they were all struck. So then it just became a matter of the 2 counts of defamation. Count 1 asserted that Professor Scofield was defamed because of the content that the defendant was putting up on TikTok that had gotten hundreds of thousands. One statistic I saw, million views plus, naming her as orchestrating the catastrophic events at 1122 King Road, saying that she had retained people to pull off these catastrophic crimes for her. The second count was that she was involved in a romantic relationship with one of the students. Okay, so when you look at the verdict form is on my community page, and you'll go through it. And so what had happened, she was very involved in the case for a very long time. Remember, this is filed December 21st, 2022. And before they filed, the plaintiff's counsel sent her 2 correspondences, which she admitted she got, Giard, saying, take down this content, it's defamatory, take it down. And she refused to do it. So then it went into the federal court system, and for 3 years almost, what is it? December 21st, 2022 to the end of jury trial yesterday, February 27th, 2026. She represented herself, but then she disappeared. She disappeared in September of 2025, just at the point when all of the court-ordered pretrial filings were due. All of the motions in limine, proposed jury questionnaires, her trial brief, which is where you basically give your synopsis of the case, and you give legal authority, and you, with the evidence, will show at trial. She didn't exhibit list, witness list, all of these things that were due. I came out a couple of times and I thought, is this going to be an empty chair trial? Is it just going to be the plaintiff there? Because it just went on for months. And it was September, I think it was like September 20th or the 23rd was her last filing. She didn't file anything at the end of September. October was when all the pretrial things were due. Plaintiff, they met every deadline. Nothing in October, nothing in November, nothing in December, nothing in January. She turned up at the pretrial conference, which was the end of January last month, and is then trying to play catch up, and she filed a motion to extend the trial date. Judge said no. Maybe he would have said yes if she had been involved. Don't know. maybe he would have said no anyway. But the motion to adjourn the trial, she filed a motion to dismiss the complaint. That was also denied. And then trial started this week. We did reports every day on the trial. It's on our content if you're interested. I've published the minutes each day, a synopsis of what happened every day. Perfectly Broken is screaming for Hunter. It is very important. I know you've been following that case, Perfectly Broken. And it's probably, if you're going to follow one case, that's the case to follow. In any event, so we get the verdict last night. The plaintiff put on a case. She was Tuesday, Wednesday, Thursday, and the beginning of Friday. Plaintiff rested Friday morning. Defense came on. She had one witness herself. And then it was given to the jury before noon yesterday. And they were out a couple of hours. That was it. And they returned a verdict of, remember, liability had already been determined. Liability was determined in 2024 on it's a federal rule of civil procedure filing. It was a motion for partial summary judgment. It was just damages, zero damages, or, could it be? And what I've been saying all along, watch out for the punitive damages, because she got the ability to seek punitive. That's punishment damages. This is in some ways to not just, slap on the wrist for the defendant, but also, hey, everybody else, don't do this. Rebecca, you're saying you were happy with that verdict, a $10 million award. They came back, right? Perfectly Broken is on top of things here, $10 million. You know what most of the money was, Perfectly Broken? Punitive damages. Half of it, $5 million. It was the last item on that 2-page verdict form, was punitive damages for count 1. And that was the count that said that she had been defamed because the defendant went out and publicly stated that she had orchestrated. She was the mastermind of these crimes. Then there was another million or 1.5 for punitives for count 2, compensatory. It might even go up more because she asked for attorney's fees and costs as well. Okay, she might get hit with an attorney's fee, and this is 3 years almost. How much is it? 2022? Oh, it's over 3 years. What am I talking about? It's 2026, isn't it? So she might get hit with 3+ years of these two attorneys from the law firm that represented the media coalition, their fees. Now, where she also, I think, made a big, big error, and this is in my opinion, right before trial on the 18th, as we had reported to you, the plaintiffs wanted the court to take judicial notice of 3 things. Mr. Cobberger's aforementioned indictment. Where's Blueberry? That was one of the documents that they wanted the judge to take judicial notice of, and therefore the jury to know about the indictment, the guilty plea, that agreement that was signed by Cobberger, Ann Taylor, and Bill Thompson, and Ashley, not Giard, the other Ashley from the prosecutor's office. This was June 30th of 2025. And then the third document, take judicial notice of Judge Hippler's sentencing, those 3 documents. She did not respond. The court said, okay, remember what we said before due process? Notice, opportunity to be heard. You have an opportunity to be heard. You need to file your response, whether you oppose, you have no opposition. She didn't file a response. This was last week. And there's Mamos, yes, citing Hunter versus U.S. Very important case. Now, not to, play, I guess I'm going to have to play Monday morning quarterback, because I said this as soon as I saw that. Judge, the case is under seal. 8 months later, the case is still under seal. Plaintiff's counsel right over there tried to convince Judge Hippler in July of 2025 that this case needed to be unsealed, and he denied that request. Oh, and number 3, guess what? The Supreme Court's getting ready to hear a case called Hunter versus United States that might have a big impact on that waiver of appellate rights. It might change everything. It might lead to a Kohberger appeal. She filed nothing. So you know what the jury heard yesterday? The jury heard that Mr. Kohberger was indicted for these crimes, and not the plaintiff, Mr. Kohberger. Number two, Mr. Kohberger signed a guilty plea, and there he is. You know, he's agreeing that he committed these 5 felonies. And here's the sentencing. He's in prison. That's what the jury heard yesterday, right before they went into that jury room. So what is next? Well, she has what? She's got what? She's got some options. Okay, I'm sure maybe she's going to file a motion to set aside the jury verdict. Good luck with that. Is she going to file an appeal to the Ninth Circuit Court of Appeal? That's a possibility. Maybe she'll try to work something out with the plaintiff. You know I owe you $10 million versus this. Will you take that? Sometimes they will. Will you take a public apology? You know, and whatever cash I can pay on a monthly basis. You know, things like that. Otherwise, with this verdict, this plaintiff can start going after her and trying to go after her assets. I've learned it's not in the record anywhere, but that she was in the Army. So maybe she has some sort of a pension. I really don't know how the military works. Maybe she's some assets. You know, maybe she owns some we don't know. We don't know. Any future assets, if she decides to get a job, she worked in human resources, is what we learned. And if she decides to get back into that in the future, you know, her future employer may be getting a wage garnishment order coming in. So maybe she'll try to work something out, structure some sort of a settlement. Because I remember, I'm trying to think of a similar case. Well, here's not a similar case, but you all know about the O.J. Simpson matter, right? Yeah, perfectly. I agree with you. That's where she flubbed. That's the last thing, the last 3 things those jurors heard before going into retiring into the jury room. O.J. Simpson was, of course, very famously found not guilty in the trial of the century of the 90s. I thought that this case was going to be the trial, at least of the year, if not the decade, before that guilty plea was entered. And then what happened? Well, the 2 families, the families of Ron Goldman and Nicole Simpson, filed a civil suit against Mr. Kohberger, against Mr. Simpson, and won. And so they were able to take over whatever like he was going to write a book, and they got the rights to the book, and he was trying to supposedly change. Oh, my pleasure, Al. Trying to sell some of his memorabilia that really should have gone to the families as part of that judgment. And how about that? You know, some people believe in karma. I hear karma so much. I don't. But a lot of people feel that O.J. Simpson was involved in these crimes and he got off. That's what a lot of people feel, even though there's a verdict that says he was found not guilty. He's arrested in Las Vegas at a hotel over some of his memorabilia that he felt belonged to him, that really was part of that civil judgment. So that's where going after, hey, Leslie and Billy, glad that you're here. Thanks for being here. That's where there might be, you know, some incentive to try to resolve this with Professor Scofield. Okay, so that's case number 1. We're going to continue to report on this case of Scofield versus Giard, aka the Idaho 4 defamation case, where the jury returned a verdict in favor of plaintiff Scofield just yesterday of $10 million. The next case I'd like to speak about, another federal case that is more recent than Scofield versus Giard. It was filed January 7th, 2026, just a little under 2 months ago. Do you have if you've been following the channel, do you know what that case is? It's the second federal case out of 3 that we're going to be talking about. You're asking a really good question. That on point, Rico. Hang on. We're going to get to that in just a minute. But that on point, Rican, is correct. It is the case of Steve Gonsalves et al. Versus Washington State University. Now, that case was initially filed in state court. And is it Skagit or Shagit County? I don't know Washington State very well. I apologize if I get the names of towns wrong. But J-Rod has this absolutely correct. The second case is the WSU lawsuit, sued by the four personal representatives of the students, Kaylee, Madison, Xana, and Ethan. Their parents, four of their parents, are PRs, personal representatives of them, and they are suing Washington State University. They are, count one is what got the case removed to federal court. Title IX. Title IX is a federal statute, and it requires universities and colleges and high schools that receive federal funds that they have to make sure that their programs do not discriminate on the grounds of gender. Title IX. And then there was wrongful unaliving, and there's negligence actions. It was a very, very long complaint. I know that many of you have read it. So what's WSU do? Well, WSU is represented by the Attorney General of the state of Washington. And what he did on the 27th of January, he removed the case to federal court, meaning literally go into the state court, pull that case out, open up a new case in federal court, but couldn't go to the Eastern District of Washington because Skagit County is in Western Washington, not far from Seattle is what I'm told. It needed to be removed to the Western District. But 3 days later, after they filed the removal paperwork, opened up the case in federal court, what does WSU do is they filed a motion to transfer venue. They want the case moved from the Western to the Eastern District. Now, one thing I want you guys to know, because I know that you're looking at this and you're wondering, should this stay in the Western District? Should it be in the Eastern District? You know, some of you feel, yeah, it should stay in the Western District. You know why? Many of you have been asking, was Scofield versus Giard, was it recorded? Could you listen to it live? Could you watch it on repeat? Could you watch the presentation of the evidence? Could you watch the trial? No. You know why? Federal courts historically, unlike state courts, they do not record their proceedings. You're not allowed to have even like photographers. If you have a cell phone, you usually can't go into the courthouse. They're very, very strict. However, there was a pilot program that was initiated in federal court a few years back, and just a few courts across the country, federal courts, are part of that pilot program. You know what one of them is not? One of them is not the District of Idaho. That's why you didn't see anything live. You're not going to see anything on replay. You're just going to be able to read the transcript, the notes, the filings from the court docket, and have to rely on the few people maybe that were in the courtroom. You know who is a part of that program? The Western District of Washington. You know what that means? There's a possibility that some of the proceedings, maybe even the future trial, if it makes it to trial, will be telecast, could be, no guarantee, but could be telecast live. All right. So plaintiffs want it to stay in the Western District. They filed an opposition motion last week, and then just yesterday, here comes Washington State University. They filed a reply. Remember, it's motion, response, reply. Whenever you're looking at briefings, you're going to typically see three. And they want this case moved. And they gave all of their reasons why they want it moved to the Eastern District. But then, if that wasn't enough activity in WSU, Gonsalves et al. Versus WSU, holy smokes, what happened? Motion to strike the answer and affirmative defenses. That would be catastrophic for WSU if they get their answer and affirmative defenses stricken. There are multiple grounds that the plaintiffs are alleging. The first and the one it's black and white. There's no shades of gray. Is they're saying that Washington State University was served with process, and under the Federal Rule of Civil Procedure 81, because this was a case that was removed, they needed to answer that complaint. Either you file a responsive pleading like an answer. Okay, you're pleading. When you hear the term pleading, WSU's pleading is their complaint filed in state court. When you hear defense is pleading, that's the answer in affirmative defenses. Remember affirmative defense number 1 when they said, hey, you might have other parties or organizations that's responsible for you for any damages, and that opened up, well, who were they talking about? Is there going to be potentially a third party defendant here? That's what plaintiffs are looking to strike, their entire pleading. So what they're saying is, number 1, it was filed late. They filed their answer in affirmative defenses without leave of court. When you hear that term leave of court, that means without permission of the court. They went ahead and they filed their answer in affirmative defenses. Yesterday, the main argument is you violated Rule 81, and they cited to case law that said, you needed to get this in beforehand or ask for leave of court. And then they said it was bad faith that they denied things that they shouldn't have denied. They filed a pleading, a paper in bad faith. They didn't use good faith. They should have admitted certain things indisputable. I don't know if that's true or not. But getting back to that first question, they either filed it in time or they didn't. No areas of gray there. Now, what they're saying is that Washington State University was served with process. What that means, usually in a lawsuit, you get a process, you hire a process server. There's process serving companies all across the country that will go and they'll find whoever the defendant is, and they'll hand over the summons and the complaint, and then they sign an affidavit. Yes, I have no relationship to the parties. I served. He got the summons and the complaint on this day, and here's my signature. And that's usually filed in the court case to prove that service of process was effectuated. Now, what the plaintiffs have been referring to, and I've always wondered about this. There's no return of service confirmation by it. Was it a process server? Did they serve the attorney general there's a process that you serve the attorney general for the state, and it is publicized right on their website what you do. If we waive service process, this is how you serve us. If we do not waive, this is how you do it. Remember, this is the government you're talking about. There's 11th Amendment issues, sovereign immunity here. It's not, if this were, University of Phoenix, private university, even though it's called out, I think it's a private university, or ABC college, private, it'd be a different story. But this is the government. This is a government it's a state university. So I had the mind to go look at the docket again today. I went up on that docket like 3 times in the past day. And then I went back to document number 1. That's the notice of removal. And there were certain documents that were attached to it. Item number 2, I believe, is the complaint in state court. Item number 3 was the summons. But all that summons says is that it was issued by the state court on January 7th. It doesn't have a return of service. And there's nothing in that motion to strike or in the declaration that was filed along with it that says, they were served the same day and they were served by a process server. And here's a copy of the affidavit of service, or they were served in some other way. And here's the proof of service. So I'm very curious, going back to J-Rod's question of how is WSU going? They're going to fight. They're going to fight tooth and nail against having their answer in affirmative defenses stricken, because they would be totally exposed. In any event, We will await that. Now, the other question is it going to be a ruling in the Western or the Eastern District? Because in line before a ruling on this motion to strike is the motion for change of venue. The return date was yesterday, the 27th. All the briefings are in now. When that reply got filed, that was it. The plaintiffs asked for oral argument. They want a hearing. As of right now, I checked because over the weekend, sometimes the clerk's office files things. Like they filed who the judge was going to be on a Saturday last month. So I checked, and unfortunately, there's no hearing that's set. The judge may rule on the papers on this motion for change of venue. If you see granted, it's bye-bye Western District, hello Eastern District. There's a courthouse. There's a couple of courthouses that are much closer to where they want to be closer to Pullman, because that's where, the employees are that probably going to be witnesses that are named witnesses. That's where the physical building is, where everything happened, Washington State University, main campus, Pullman. That's where they're saying all their records are at the main campus in Pullman. That's where Mr. Kohberger worked as a teaching assistant, main campus in Pullman. That's where any investigations that happened occurred, main campus at Pullman. The people who were involved in any they were there. They're saying now some of the students, what the plaintiffs have said, hey, some of the female students that complained, they've graduated and they're no longer in Pullman, but then there's still the entire staff that's there. And also the apartment where he was living. He was living at the, the Steptoe Apartments, right? Did I get it right? Steptoe Apartments, that is on campus housing. And hello, what's right across the state line is Moscow. So if you see motion for change of venue granted, the case in the Western District will be closed. We can say goodbye to seeing any proceedings televised, because if it goes to the Eastern District, they're not part of this pilot program unless they become a part of it. That's always a possibility. But anyway, hey, Amy's here. Thank you. Glad you're here. Amy. So if you see denied, big fat denied on that motion for transfer event, that's all you got to do. It's going to, no doubt it's going to be a long order. What I always say is make your life easy. Go to the very last page, right above the judge's signature, and you're going to look for denied or granted. It could also be on the first page. Sometimes they do that at the very beginning. But if you just want to, tell it to me like I'm a 3-year-old. What was that line from Philadelphia that Denzel Washington said? You go to the last page. If you see denied, that tells you the case is staying in the Western District, where it is in front of this judge. If you see granted, then it's going to the Eastern District. And then there'll be a, courthouse. Is it going to be Walla Walla, which is closer? I think the closest one to Pullman. Will it be in Spokane? Don't know. That's also closer to Pullman, according to what we've learned. So we're waiting for that. Oh, so glad, Soul Sisters, you come here that's what we try to do. Everything is always based on the filings. You'll very rarely see us citing to something that's not in the filings, because we want verifiable issues. And then you guys can go ahead and make up your own decisions as to how you feel about stuff. Okay. So we are waiting for that motion for change of venue. I'm predicting, I don't know if she's going to deny or grant it. I can't, but I'm predicting that will be resolved first. And then the motion to strike will be resolved second. All right. Then what you're going to see is, let's just say it's denied. The judge has already said that she's going to put out the scheduling order after that motion to transfer venue is done. Once it's ruled upon, you're going to see a scheduling order come out, and that might have a trial date on it. It's certainly going to have when discovery has to be completed by, any third-party practice, when court-ordered mediation, which federal courts require the parties to go to mediation. And that mediator's job is to try to get the parties to resolve the case. All right, so we got that in the works in the case against Washington State University. They've already asked for that. Mamos is asking a very important question relative to Gonzalez et al. Versus WSU. they asked for reimbursement of their attorney's fees and court costs in their answer to affirmative defenses. Hello, though, we have to now see if they're going to get that pleading struck. Just something tells me the Attorney General's office has got to have a good reason here. I can't see them. I mean, they win all the time. They sue the federal government. They just got a great result out of this judge in December after the Attorney General of Washington, in conjunction with multiple other attorney generals across the United States, filed an action against the United States Department of Education, who had cut all of these grants and these monies after these school pew-pews had happened. Well, they sued basically the federal government and they won. And it was this state attorney general out of Washington who led that battle. All right. So we'll wait and see what this response says. Of course, the minute it hits the docket, I will be undoubtedly preparing a presentation for you, letting you know what their position is. And of course, when these rulings all come down, you'll be the first ones to know. All right. Are we ready to move on to possibly one of the most important hearings in Mr. Kohberger's life, even though he's not a party to it? And I know that you guys know what we're talking about because we've been addressing it. You know what case we're talking about that's coming up for oral argument 10 a.m. Tuesday, the 3rd of March? Mamos is predicting the WSU case is going to be messy. I think each side, I believe, is going to very aggressively fight this case. This is not one of these where it's, one case amongst, all of these other cases that either side has. I think, Mamos, it's going to be very hotly contested on both sides. WSU does not want their federal monies messed with. It's Title IX funding from Washington that I'm sure they depend on. Oh, here we go. We got everybody here. Here we go. Thank you, Elle. Love you too. Thank you for being here. Hunter, reigning Rebecca has been following the Hunter case, I believe, very closely. Elle's got it too. She's got her eye on that case. And Mamos, Hunter versus U.S. Okay, let's talk about Hunter versus U.S. Hunter it's a guy. I think it's Mumford Hunter III. I get his first name wrong. He is petitioner. He is the defendant. This is a federal case. He was brought up in charges in federal district court in Texas. These were it sounds, I really didn't read, the claims, it appeared to be financial type things, maybe dealing with banks, interstate, things like that. He agreed to a plea deal before trial. He agreed to now when someone enters into a plea deal, hopefully you will never enter into a plea deal for anything. But when a defendant like Mr. Hunter, like Mr. Cobberger, and like so many people do, when they agree to give up all of their constitutional rights and enter into a plea agreement with the state, in addition to, hey, we're going to make sure this is it, we're not appealing anything. It's an appeal waiver. That means giving up a right to go. Love and other habits, just a mediator appointed by the judge. It's usually the parties who agree on a mediator. And then if the parties can't agree on a mediator, then it might have to, the court might have to get involved at that point. But usually 99.9% of the time, the parties are able to agree. There's usually in every judicial district, there's going to be a list of mediators. All right. So let's get back to Hunter. Mama's thinking, she's looking at Hunter. Everybody's looking at Hunter. J-Rod's looking at Hunter. He's saying, will make my whole true crime content creation career take off. Okay. And make sure you're following the content creators that are here. Consider, they're doing things independently. We had A.R. Hayes was in here. J-Rod, Al are all here, independent voices. So then so Mr. Hunter, in addition to, okay, I'm going to give up my appeal rights, which I do not believe in. I think that there should always be a higher authority that someone should be able to go to have a higher authority look at a case. That's just me. I think it's a matter of public policy. And I think it's also the amicus, the people that filed legal briefs, the organizations that did, and there were multiple, and they all filed in favor of Mr. Hunter. They all filed. They're all on the court docket. I've done a bunch of, I've got a playlist that I've assembled for you so that you can see what some of the, what both sides are saying, why the appellate waiver, why there should be more grounds to appeal when you sign away your rights, why that should stand the way it is. But then there's also amicus briefs, and that's in our playlist. So what he did is he gave up, just like Mr. Kohberger, when he agreed to enter a plea of guilty, gave up his appellate appeal rights, gave up his right to remain silent. That is constitutional. It gave up his right to confront witnesses against him. Constitutional right. Ditto. Due process privileges, right to notice, opportunity to be heard, and a fair and impartial judge, jury. Gave up constitutional right to a public trial. So this isn't, small stuff. This is stuff that the 13 original colonies, after they were, and Al, we've had this discussion, I think, before, you and me, about when we're feeling like we're the underdogs and we're up against a massive battle. Just think about what the 13 original colonies did. All right. This was a bunch of people who were not organized. They were brought over from England, and it was their children and their grandchildren, their great-grandchildren, to settle in this land. And they did. There were 13 original colonies. It was Pennsylvania and Maryland and the Carolinas and Massachusetts and whatnot. And they fought against the most powerful and well-organized military in the world, the British Army, and they won. A lot of times they didn't have food. They would catch all types of, pneumonia. They would die. There was no medicine. They didn't have shoes sometimes, much less uniforms. Crossing the Delaware, December 26th, that George Washington, when they crossed the Delaware River from Pennsylvania, New Jersey, and they don't have coats, and it's snowing and it's cold. I mean, that's who won that war, the War of Independence that we celebrate every year when we, the Declaration of Independence every year, July 4th, 1776. We're celebrating that gumption, that get up and go, that Davy and Goliath story. So when all of you, whenever you think that you're an underdog, just remember them and think of what they demanded. Then you had the people in Pennsylvania who were going to be the leaders of this new country that wanted the states, and well, they're not states yet, there were 13 colonies, to sign this constitution. Whoa, wait a minute here. We just went through this multiple year. We've lost family members. This was an unwinnable war. Somehow we won. We are not going to sign a constitution so that now you get to be a central government and we have to deal with another king or queen again. No way, no how, never happening. So it was to appease the states that you got the Bill of Rights. And what's right at the top of the Bill of Rights? My personal favorite. I quote it all the time. First Amendment, freedom of speech, freedom to press, freedom of religion, petition government, assemble peacefully. They gave us 5 freedoms in that first. And I got to think, why is that one at the top of the list, the 5 freedoms? I got to think that was extremely important to the framers and, more importantly, the original 13 states. Well, they also gave us, Second Amendment, Third Amendment, Fourth Amendment, no quartering of soldiers. Third Amendment, very rarely spoken about. It's because of what we just talked about. They had to answer to a king. And if there were soldiers that the king happened to send over to the New World, and a soldier said, hey, get out of I'm going to be living in your house now, man. Your wife is going to be, cooking for me. And you can't do anything about it. No quartering of soldiers. That's what the Third Amendment means. We're not doing that again. All right. So they saw fit. So you get, and over the years, the Constitution is a brilliant document, I think, because it's, what is it, almost 300 years old. It hasn't been amended very many times. The first 10 were a package. That's the Bill of Rights. So this is what a defendant like Mr. Hunter is giving up. All of these freedoms guaranteed by the ultimate underdogs who have my ultimate respect always, for giving us, having the fortitude to look in the future 300 years and recognize how important due process was, how important free speech, how important it was to be able to exercise whatever your religion is, or no religion at all. That's what the First Amendment says. So we got to give them respect for that. That's what Mr. Hunter gave up when he signed his name on that plea deal, and Mr. Kohberger as well. A lot of people here are saying, we're going to look for the truth. We're going to try to get Mr. Kohberger free. How? Right now, there's only two possibilities. Number one, governor of the state of Idaho would have to pardon Mr. Kohberger. What odds do you put that? I'm putting that as probably a 0.0000001 chance that will ever happen. Number two, I hope you won't take it personally, Glenn, because I know you're across the pond, as they speak. But yeah, I'm proud of what the 13 original colonies did, and very protective of that Constitution, that Bill of Rights. I think we all have to be. Hi, thank you, Written Dreams. Glad that you're here. Okay. Elle, you get an A if that's what we're doing right here, because you always get the answers right whenever we do quizzes. All right, so we got now Mr. Hunter, who was sent in. Okay, so how's Mr. Kohberger ever going to get out of jail? Prison. No, excuse me, not jail, prison. One possibility is that the governor of the state of Idaho would have to pardon him. The other possibility is that he would have to get a new trial. That sentence would have to be set aside, and only if the prosecution decided not to refile, which 0.00000, even less, if there's anything less than 1, that's the chances of that ever happening. I think he's got to get a new trial. How's he going to get a new trial with signing away his appellate rights? People who say, oh, well, the the evidence, this, okay, yeah, very, hey, nobody has written about the shenanigans with the sheath than I have. I've identified multiple problems with that sheath once we started to get the documents uncovered. You know what? It's a big so what. Not going to do anything. It's just a discussion that we can have until the governor of the state of Idaho pardons him or he gets a new trial. And right now he's got a big problem. It's not like, Richard Allen, which we're also covering. We're covering the Allen appeal, Allen versus State of Indiana, the Delphi case. Mr. Allen did not plead guilty. Mr. Allen was convicted at a jury trial, and he is appealing the sentence that Judge Gull rendered on Fourth Amendment grounds. Different situation. Very hard. Very, very, very hard to set aside a waiver of plea, a plea waiver. There's two grounds. Remember when Hitler was talking about Garza versus State of Idaho? Does anyone remember the Garza case? Yeah, he had talked about, if you go back and you listen and watch, it was I think it was a change of plea when he raised Garza. Oh, we know that a waiver of appellate rights isn't really, a waiver. Talking about Garza. That is a SCOTUS case. That's not a State of Idaho case. That is a Supreme Court of the United States case. Looking at the federal Constitution, because the Supreme Court of the United States is the ultimate authority as to what that Constitution says or does not say. There's no one to go past the Supreme Court. That's it. And Garza was passed back in 2019. That's what Judge Hippler was referencing. And across the country, there's a lot of disagreement. What is it that the one thing that they agree on? You got a bunch of appellate courts all throughout the United States. The ninth happens to be the Ninth Circuit Court of Appeal, happens to be over Idaho and Washington. That's why you see the Ninth Circuit quoted, and why you're going to see it quoted a heck of a lot in Washington in the forthcoming matter of Gonzalez et al. Versus WSU. It's federal court. Dad and mom are the Ninth Circuit Court of Appeal. Granddad and grandmom are the United States Supreme Court. That's how it works at that level. All right, so under Garza, what most of the appellate courts across the country believe, there could be an exoneration, but that would have to come from the governor. Or, hey, maybe Bill Thompson would possibly exonerate him or her, but then they'd still have to go to court because they got the guilty. That's the one problem. This is the easiest way. Easiest. This is what could change everything for him. If the Supreme Court does not add more grounds for someone to be able to appeal, Mr. Cobberger will spend the rest of his life in prison, more likely than not. That's why when they say that, they're not saying that for no reason. It's because of that appellate waiver that he signed. What are the two grounds that most of the appellate courts agree on? Well, if you have ineffective assistance of counsel, you can move to set aside that plea agreement. Problem here is it doesn't look like Mr. Kohberger is dissatisfied with counsel, because unlike most other cases where whoever your trial counsel was, if they were appointed, if it's private, they're done at the time that sentence comes down. Here, July 23rd, it was a plea deal, sentence July 23rd, criminal case closed. He's still being represented by the same attorneys who represented him today, almost 8 months later. As a matter of fact, all three appeared at that hearing back in November. Remember that hearing that Hippler had? It was his three defense attorneys, all women, who appeared at that hearing. That was November. And it's Taylor who has been filing the responses regarding the unsealing of documents. All right? So at least where I'm standing, hey, if he's not happy with counsel, it's going to be a tough argument to make right now. The other one is if Hippler sentenced him to more than what the state required. And that's part of Hunter's argument. He's saying he was sentenced to more than what the statute required for what he was charged with. Now, Mr. Cobberger was looking at the DP. And I think that Hippler was very careful to make sure that he didn't go beyond when he 10 years, life. So, but Hunter is not just looking at it just for himself, for his specific. It's a bigger picture. Hi, Charm Frey. Glad you're here. Thank you for being here. He's asking the Supreme Court, are there more opportunities that if someone signs a waiver of appellate rights, they agree to give up of their own free will, their appellate rights, over and above ineffective assistance of counsel, and if the judge sentenced the person to more than the statute allows. They're going into due process land. Okay, and again, with due process clause, notice, opportunity to be heard, fair, impartial, judge, jury. Now, the amicus briefs, I definitely recommend that you read them. We got the playlist, we got the shortcut for you. I tell you where to look on these, because some of them are really long and very, very complicated. well enough, equipped enough to read them. But there's one brief from an organization, not for profit, located in Washington, not Washington, it was on the East Coast. And it provided statistics. There was they did a scientific analysis of, will people agree to plead guilty when they know they're not guilty? And that's their whole position. It is scientifically proven that people will sometimes plead guilty even when they're factually innocent. And I know that some of you have said that about Mr. Kohberger, that you feel that he was not guilty, but he signed the plea deal anyway. You're going to want to listen to that presentation that we did and watch it. We did a video here on YouTube about a month ago, and it goes into, and it'll show you, and you'll see the statistics. Someone else, another group, defense attorneys out of Texas, writes about how it's a lot of poor people who agree to give up their appellate rights. Another organization says it offends the public because these plea deals happen in secret, and the public is here to make sure to serve the role that the courts are acting properly and the judges aren't acting like kings and queens, detested by the 13 original colonies, aka states. That defense attorneys aren't overstepping their bounds. And I haven't been a fan of defense counsel in this case when it comes to transparency. It was Ms. Taylor who came up with the first version of the gag order and then went to Thompson and said, hey, let's go together and let's present a stipulation. Oh, okay, you stipulate that there should be a gag order signed at day 4 of the case. Ms. Thompson did not want issue about cameras in the courtroom. Remember, at first, it was you had media in there taking photographs, videotaping, and she had a concern, and it kept focusing in on Mr. Kohberger. And the judge said, you don't do that. You don't focus in on him. Focused on his hands, focused on him. And she didn't want any cameras in the courtroom. And that's Judge overruled that position and said, okay, we're going to have the Latah County camera system record from now on. She also didn't want the gag order set aside in July. She opposed that. And she filed more than her share of motions to seal documents and also stipulations with the state of Idaho to seal documents. And you know how many of those motions and stipulations were denied, where the court turned around and said, now the public has a right to see this information exactly 0.0.0, not 1. In any event, that's just me. I'm a very big proponent of the First Amendment. I'm very concerned about the secrecy of this case. I don't know why it was as secret as it was when it was being prosecuted, as tragic as these crimes were, and they are mind-numbingly tragic from what we know. Unalivings happen all too frequently in the United States. Law enforcement agencies who investigate will give the public some information. Moscow Police Department gave literally very, very, very little. They used 2 stand-ins for suspect vehicle 1. Remember when they put out the bolo to be on the lookout? They refused to have even an image of suspect vehicle 1. They had 2 cars, one with a sunroof. Last time I saw Mr. Kohberger's Elantra, didn't have a sunroof. I mean, they wouldn't even released a photo of that vehicle. They had no reason. Okay, why wasn't 911 called for 8 hours? They wouldn't release the 911 call. They wouldn't release a transcript of it. Look and see what other law enforcement agencies across the country do in the name of transparency and in the name of the First Amendment. And then compare what Moscow Police Department. And then we go into the case for more than 2.5 years, and it's still sealed to the public, no matter what the First Amendment says. And now we're 8 months later, and it's still sealed to the public. 95% of it, I don't know. Even when Hitler put out an order December 18th saying that dozens and dozens and dozens of documents were to be released to the public, only 1 has been so far from March of 2025. Oh, thank you, J. Rod. It's my pleasure. Keep keep defending that First Amendment as you are doing. All right, so let's talk about Hunter. So now we got Hunter. Oral argument. What the heck is this? Is coming. It's mind-boggling. All this is happening in federal court in a matter of 4 days. We got the verdicts coming down in the Idaho 4 defamation case. We got the motion to dismiss in the WSU case, plus the final paper in the motion to transfer. All that happening the same day. Coming into Tuesday. Tuesday is oral argument before the U.S. Supreme Court, 10 a.m. 10 a.m. Tuesday morning. Now, unfortunately, we can't watch it live, and there will be no photographs. They don't allow it. But you can listen live. You can listen to the proceedings. Don't expect a ruling on Tuesday because they have to sit around and they have to discuss it. They got to come up with a written opinion so that people will know in future. Will have a situation like this comes down in future. This is how the Supreme Court interpreted the Fourth Amendment. Oh, okay. So what they're going to do is that both sides are going to have an opportunity. It'll be Mr. Hunter's attorneys first because they have the burden of proof to try to persuade those 9 justices, or at least a 5-4 ratio of them, to find that there are more grounds than there are currently to set aside a waiver of plea rights. You're going to see Mr. Hunter's, you're going to hear Mr. Hunter's attorneys arguing, and then I recommend listen really closely. And if you can't listen live, I know people work, they have other commitments. You can listen to it on replay. Listen carefully to what the justices say. Not so much what the plaintiffs say, because their arguments are on paper in the petition, the response, and the reply brief. You can see what their positions are. It's what comments are the justices making? What questions are the justices asking? What follow-up inquiries are the justices making? That will give you, I believe, a possible insight into how they may rule. Okay, do we have enough consent here that this looks like at least 5 of them are going to rule in favor, maybe not a full victory, but a partial victory in favor of Mr. Hunter? Oh, is this sounding really like they're agreeing with the U.S., the government? And then the ruling will come down. The ruling will come down before the end of June of 2026, because that is when the Supreme Court closes up shop until the first week of October. So it will be on or before the end of June that you're going to see a written ruling, and you're going to see what the decision is, and that is Hunter versus U.S. It could mean nothing to Mr. Kohberger and people like him. It could mean everything to Mr. Kohberger based on this case, Hunter versus U.S. Any questions, guys? I know we've been on for a lot long. Oh, 60. If you could hit the like button, and if you don't subscribe to the channel, I'd appreciate it. Please feel free to share our content. We're trying to get our word out there into the information highway, whatever it is. Hit the like, y'all. Thanks, Al. Thank you. Okay. Any questions, comments, thoughts, opinions? Mamos is thinking that it will be huge. Mamos, do you feel that it might be a good decision when it comes? Well, let me ask you this. We can't predict. We can't predict. We're not tarot card readers here. That was a bad joke. Forgive me. Mamos, are you going to listen to the proceedings either live or replay? How about the rest of you guys? Al, I think that you've pretty much committed that you're going to be listening in. Amy, what do you guys think? Rebecca, you've already said you're listening in. I know a lot of you are. Definitely. Yeah, perfectly broken. I think you put that on your calendar the first time that you learned about this case. Trying to owe 10. Good work, Al. Good work. Good work. Yeah, I think it's important too for the Supreme Court to see lots of people, just everyday people from not just here in our country, but possibly globally, that are signed in to listen to this event. They're supposed to go by the law, but they keep, I think they keep tabs somehow. Somebody at the Supreme Court is going to look to see, oh, okay, there's only 200 people listening in versus, oh, there's 5,000 people there's 25,000 people that are listening in. This must be really important to people. Okay, we're not Tara. Okay. All right, guys, please, if you can, subscribe to the channel. I really appreciate it. Share our content and comment above everything else. What this channel exists for is to help to promote the First Amendment, freedom of speech, which is, everyday people, whether you're here in the United States, whether you're in a territory like that on Point Rican is in Puerto Rico, territory of the United States. He's very concerned about the Constitution. It impacts him just like it impacts all of us. If you're, friends, England, former enemies, now friends, South Africa, we've got people listening in. From the first listener was from Tokyo, Japan, when I started my podcast. Talk about the cases, debate the facts. People I can't give anybody any advice. I just can't. I mean, it would be imprudent to do that. But, debate. You got a First Amendment right to discuss things. Just be careful about what you're putting in writing about people. That's it. Remember, the defendant in Scofield versus Giard was given 2 written opportunities before the lawsuit was ever filed to take down that content. And from what I understand, when Miss Scofield got up on the stand, and she sounds like she's very much a self-made person. She put herself through Harvard. She teaches about different cultures, LGBTQ issues at the University of Idaho at Moscow. And from what I understand, I'm waiting for the transcript, is that she said that this was very difficult for her, that she feared for her family, her safety, that it impacted her. And her mother got on the stand. Her husband got on the stand. So thank you. Written Dreams is here. Thank you for leaving your DNA evidence on the like button. Debate the case. Debate the facts. All right. So if that's it, thank you. So thank you all. I really appreciate you being here this morning. Again, this wasn't planned. We might do something on Tuesday, either before or after the Hunter case. If we do, probably be maybe Tuesday night to talk about the case and what we might have learned at oral argument, important questions, feedback that SCOTUS may have given us clues, breadcrumbs as to how they're leaning. Okay, so hang out with us if you can Tuesday. I'll put out a link at some point. I know, raining, Rebecca, I do. I mean, it's, this is 3.5 years. So, all right, thank you. Have a great weekend, everybody. And we'll see you again. This is Kathy signing out. Bye for now.